Good afternoon, everyone. Thank you for joining us for our technology series presentation today. My name is Milam Newby. I'm an M&A private equity and venture partner at the firm, and I'm also head of our global technology practice. We look forward to sharing with you an overview of the new cybersecurity disclosure rules. It's my pleasure to introduce our speakers, Catherine Frank and Rajesh Patel. Catherine is a partner in our capital markets group, where she principally advises public companies on disclosure, compliance, and offering matters. Rajesh is a counsel in our tech practice and assists companies in their development and commercialization of intellectual property. It's my pleasure to turn it over to Catherine and Rajesh.
Good morning, everyone, and thanks for joining us today. So if we could go to the next slide. Next slide. So in July of this year, the SEC approved final rules requiring public companies to disclose material cybersecurity events on Form 8K. And they also added two new Reg SK items regarding cybersecurity governance and oversight processes for public companies, and both of which are required in Form 10K. So we put up the due dates here in order of application. It's actually the Form 8K item 105 that's going to kick in for most of you here in about 6 weeks. On Monday, December 18th, 2023, you'll be required to file item 105 8Ks covering disclosure of material cybersecurity incidents. And then for most 12/31 fiscal year-end companies, starting with your next 10K, which should be filed in February or March of next year, you'll be required to include the two new Reg SK items covering cybersecurity governance and risk management. Next slide.
So I'm going to be talking about Form 8K first, and then I'll go to Form 10K. Form 8K item 105 relates to the reporting of material cybersecurity incidents. Within 4 business days of determining that a cybersecurity incident is material, a company must file a Form 8K that discloses information regarding such incident. However, there are certain national security exceptions, which will be briefly discussed below. Materiality should be determined as soon as reasonably practical after the company discovers the incident. Generally, a company will not be able to make this determination the same day that it discovers the incident. Once a company determines that it experienced a material cybersecurity incident, it must file a Form 8K and disclose, to the extent known at the time of filing, material aspects of the nature, scope, and timing of the incident, and material impact or reasonable likely material impact on its financial condition and its business operations. As new information comes to light during the investigation and after a company files its initial Form 8K, the company must file amended Form 8Ks as material new information about the nature and severity of the incident is discovered. Next slide.
Well, if I can jump in real quick, I just want to highlight 2 things here that are important that the SEC highlighted in their final rule. The first is they do not have the expectation that you are going to be able to determine whether you have an 8K trigger on day 1. They fully expect it to take a few days to decide and to work through your disclosure committee to decide whether an 8K is actually required. The second thing that they've honed in on is this obligation to do an amended 8K. And this is a pattern you're going to see later in our presentation, where the initial 8K that's filed within 4 business days of materiality is very short. It doesn't have all the information available. And then a second 8K follows, or an amended 8K follows under the new rules within a couple weeks, sometimes a month, that actually discusses these 2 bulleted items on this slide, especially the material impact or reasonably likely material impact on the registrant, including its financial condition and results of operations. If you have an ongoing active cybersecurity incident, it's unlikely that you or your company is going to be in a position to create public disclosure that you're ready to put out there within 4 business days. And the SEC has acknowledged that. And the other thing I want to note, for those of you who are securities lawyers, is that the SEC has put these item 105 8Ks on the list of 8Ks that do not impair your S3 eligibility if they're late. So typically, by way of background, if you are not timely in your 8K filings, well, certain 8K filings, you'll lose S3 eligibility for a year, which makes it more difficult to access the markets. There is a list of certain 8Ks that do not trigger this loss of 8K eligibility. This item 105 8K is one of them. So if you're ever second guessed on your 8K trigger date, the consequence will not be loss of S3 eligibility. So Josh.
Next slide. So a company may delay its filing of a Form 8K past the 4 business day requirement, but it's only if the U.S. Attorney General determines such disclosure would pose a substantial risk to national security or public safety. The initial delay would be up to 30 days following the date the disclosure was otherwise required, and extensions are available if the U.S. Attorney General approves it.
And
go ahead. As of right now, it's unclear how the companies are to contact the U.S. Attorney General at this time for determining whether the disclosure would pose a substantial threat to national security or public safety.
Yeah, the only thing we've seen so far is that the FBI has put up a web page that says that references this rule, but it doesn't give any instructions other than its general rule for cybersecurity crimes, which is to contact your local field office or to call their cyber crimes hotline. So there's no guidance really here on how to reach the Attorney General or what considerations they'll take into account when they decide whether to give you a delay. So this is a piece that we're still holding on.
Right. The other thing that I have seen in articles is once the Attorney General does become aware of it and that it is a national security or safety risk is present, the Attorney General will be the one that will communicate to the SEC and request this extension. Next slide. So Regulation SK Item 106B relates to the disclosure of the company's cybersecurity risk management and strategy on Form 10K. On Form 10K, companies must disclose the following. It must disclose its risk assessment program and its activities for assessing, identifying, and managing material risks from cybersecurity threats in sufficient detail for an investor to understand those activities. It must also disclose whether cybersecurity risks have already materially affected or are reasonably likely to materially affect the financial condition and/or its business operations. As you can see, these are not just forward-looking, but also look to see what's already happened. It must also disclose whether the cyber risk management processes have been integrated into the company's overall risk management processes and how they've been integrated. Lastly, the Form 10K must also disclose if the company uses outside consultants to perform or assist in cybersecurity risk assessments. These are such as penetration tests. We've seen companies usually conduct penetration tests at least annually. Catherine, anything on this slide? Okay, next slide. Regulation SK Item 106C relates to the disclosure of the company's cybersecurity governance on Form 10K. On Form 10K, companies must disclose the following: a description of how the board of directors provide oversight of the risks from cybersecurity threats, whether or not any board committee or subcommittee is responsible for cyber risk oversight, and if so, describe the processes by which they are informed about these risks. Whether and which management positions or committees oversee cyber risk, and whether the company has a chief information security officer or someone who serves in a comparable position, And if so, who does that individual report to, and what is the relevant experience of that person? Relevant experience is typically the relevant work experience in cybersecurity, any degrees or certifications that they possess, or any other knowledge and skills and background that they may have in cybersecurity. The proposed rules had a requirement that the company disclose the board of directors that had experience with cybersecurity and what that experience was. In the final rules, the SEC removed this requirement, but it did hint that the company may still need to disclose such expertise if the company determined that board level expertise is a necessary component to the company's cyber risk management.
Yeah, that was something that folks were very concerned by in the proposed rules that didn't make it into the final rules, because there are only so many former chief information security officers who are available to serve on public company boards. Their little threatening note here about needing board level expertise as a necessary component to the registrant's cyber risk management, we take to mean, if you are a company who is particularly subject to certain cyber risks, a tech company, or maybe critical infrastructure, maybe that's something you might consider, is finding a specific cyber expert to sit on your board. I do want to pause for a moment and talk about this 10K disclosure, because many of you may be drafting this disclosure now to put in your 10K in a few months. Traditionally, the disclosure that you find in this section was kind of spread out in a few different places. You would certainly see a cyber risk factor, and that's where the bulk of cyber disclosure was typically found. There might be some cyber risk management disclosure in your proxy, where you talk about board oversight of risk management. And then if you're a company, again, who's subject to specific government regulation due to the type of business you do, you might have a paragraph in your business section in the government regulation portion that discusses the particular regulations that your company is subject to. So the SEC is really asked that you move all of that disclosure under this new umbrella, this new item that falls under risk factors in the 10K order. I would assume that you would keep the existing disclosure where it sits, and this would, to some degree, be repetitive of those other places. And as you prepare that draft, I would encourage your companies to do three things. The first would be to take a look at your governance documents and committee charters and make sure you have clear delegation of authority to the appropriate committee or to the board as a whole for cybersecurity risk oversight. You're also going to want to poll your directors and their D&O questionnaires and make sure you understand what experience and certifications they might have that you can include in this section. The second thing I would recommend is to work now with your chief information security officer and your IT personnel to understand your cybersecurity framework, and so that it can be properly and accurately described. You do not want to overstate or exaggerate the processes that you have in place. The third, I would also resist using boilerplate language that you might pick up from earlier 10K filers. I know we all love to look at our peers and maybe start with their language, and that's fine. But I would encourage you, given the SEC's interest in commenting on risk oversight disclosure, to think carefully about the specific risks that your company faces. Do you have personal client data or health data? Do you have credit card records? Do you have critical infrastructure like transportation or pipelines? Those items, those company-specific items, should be described in this section. It shouldn't be just a rote description that you're pulling from another filer. Next slide. Next slide. So, next slide, please. So the first question we get on these, particularly on the 8K disclosure, particularly because that deadline is coming up, or that effective date is coming up, is, what does materiality mean in the cyber context? And the SEC spoke about this at length in the proposed rule and in the final rule, and they declined to give a really clear threshold for issuers to understand when they have to report and when they don't. They didn't say, when the costs of this event exceed $10 million, when you might incur $100 million of liability. Nothing. There's no 10% of revenue test, none of it. You are stuck with the usual reasonable investor test. And we all are assuming, right, that there really is a reasonable investor that exists out there that we're playing this game with. But it's the standard set in TSC Industries. Information is material if there's a substantial likelihood that a reasonable investor would consider it important in making an investment decision, and if it would have significantly altered the total mix of information made available. The rule gives a little bit of color commentary, which I think is helpful because it makes it really clear that the SEC is not only interested in the financial piece of a materiality test. They are also incredibly concerned with harm to reputation, customer relationships, harm to competitiveness, the possibility of litigation or regulatory investigations, and then, of course, data theft, asset loss, intellectual property loss, particularly the loss of customer or personal or health information. Next slide. So what I would hope that each disclosure committee does whenever it sits to consider whether an 8K is required is to go through something similar, a list similar to this. We've given you some rules of thumb here. So we're not just saying it's going to have a financial impact on this quarter. We are also saying, does this affect our reputation, products, or services? Is it going to affect our financial position, either due to a ransom payment, fees, remediation, whatever that might be? Does it disturb our relationship with our customers or suppliers, particularly through loss of personal data? Will it affect our operations, slow us down? Maybe it's not an immediate cost, but there's a cost because we've had to shut down operations for a few days. And then potentially you might come across a series of individually immaterial incidents, related or unrelated, that you determine are material in the aggregate. And I do want to flag here, you can't have this, you can't do this exercise where you run through these rules of thumb with your disclosure committee. And I use disclosure committee loosely here. That might mean a formal disclosure committee, or the folks who decide whether 8Ks are required at your company, CEO, CFO, general counsel. If the disclosure committee doesn't know that an event has occurred. And so the importance of updating your disclosure controls and procedures to make sure that the relevant decision makers are in a position to run through these rules of thumb is incredibly important. It's time to update those procedures. It's time to update your IT teams and let them know about the standard. And you want to cast a net that's wide enough to not just pick up the obviously material cyber events. You want to pick up the maybe material cyber events or the somewhat material cyber events in the gray zone, so that you can actually show that you've made these determinations as part of your regular disclosure controls and procedures. I got a question here actually in the chat that I think is a good one. And it is, how do you determine materiality when the incident occurred with a third party? And the third party doesn't give you all the relevant information that you need to make materiality decision, or informs you months later. If it's something, the benefit of this 8K trigger is that it doesn't hit until you can determine materiality, right? So you have some leeway to do some investigation and make some decisions when it comes to figuring out, if a third party notification of breach is something that's actually material to you as the customer. The other piece that I think, we need to think about is, we lived through the SolarWinds breach, and the SEC contacted, we think, in the high hundreds number of SolarWinds customers that were public companies, and asked them to self-report back to the SEC what their disclosure of controls and procedures looked like when they heard about the SolarWinds breach because they were a SolarWinds customer. And it's the same process that you want to be able to tell the SEC as you would want to give if it was your own breach of your own systems. Have you thought through these factor tests? What information do you have? Who internally, and it should be the disclosure committee, reacted and made that materiality determination? You can really only do the best you can. And many commenters in this rule said, well, what about third parties? Like, what do we have to do? And unfortunately, the answer is you have to sit with the information that you have and decide if you can make a materiality determination at the time. I would encourage everyone to update their risk factors to make sure they reference potential cybersecurity breaches at third parties, vendors, suppliers, customers, whoever, where you might have potential weaknesses. Next slide. And just to give you more color in the proposed rules, as opposed to the final rules, the SEC did list potential material incidents to think about. So you can see they were thinking about ransom attacks. They were talking about, interruption or loss of control or loss of operational technology systems. So again, not just losing cash. It's not about the financial results necessarily. It's also about, malicious actors having access to your systems. They really are focused on that. Next slide. Next slide.
All right, so here we have a few case studies that provide some information regarding Form 8K disclosures. However, these case studies are on the more extreme side of materiality, and so they're kind of easy to determine that Form 8K should have been filed. The first is Clorox. Clorox experienced a cyber attack in August, which caused wide-scale disruption of the company's operations and product shortages. It's predicted that the cyber attack on Clorox will cost the company between about $493 million to $593 million. And it'll also affect the company at least through Q2 of the next fiscal year. Here, there's a clipping from CNN. It can be seen that this incident affected Clorox's reputation and product, and also disturbed Clorox's relationship with its customers, so they weren't able to purchase the company's products for quite some time. These are examples that Catherine provided in an earlier slide as to how to determine whether an incident is material or not. Next slide. Clorox filed its initial Form 8K on August 14. Clorox had a very short Form 8K disclosure and merely stated the bare minimum, likely because it had determined the incident was material, but it didn't have much information at that time. Here, Clorox stated that it discovered unauthorized activity, took steps to stop the activity, and was in the process of remediating it. And it's also working to respond to the issue and implemented workarounds to service its customers. The company also stated the incident has caused and is expected to continue to cause disruption to its business operations. So you can see it was kind of short and sweet, very simple, and you can kind of tell that they were going to come out with something that was more specific at some other time. Next slide. Clorox filed an amended Form 8K on September 18. They borrowed some of the language from its initial Form 8K filing, but then added that it implemented its business continuity plans and began manual ordering and processing procedures. It stated that the unauthorized activity is contained The company also stated what happened, how it's affecting the company, what the company is doing to remediate, and that the impact is material and is still evaluating the financial and business impact. So you can kind of see that this second one occurred a little over a month later, and it was a little more detailed than the first 8K filing. Next slide.
So these next slides, you may have heard about these cyber attacks for Caesars and MGM, and I think that they're interesting because they again show that 2-8K pattern that we were talking about, at least for MGM. So this is where folks couldn't check into their hotel rooms because their key cards weren't working at MGM resorts, or were having to be manually cashed out of slot machines. So very public, very obvious, reputational harm and difficult relationships with customers because of this event. I think it happened over a weekend. And Caesars, I believe, had a much smaller incident, and they that dealt more with stealing data. Again, a customer relationship issue, but you can see the 8K patterns in the next slide. So next slide, please. So this is MGM. MGM did 2 8Ks, the usual pattern that we see, which is 1 8K that attached this press release, very quick, very short. This is what cyber press releases used to look like until the new rules came out. Again, the rules weren't in effect for any of these guys, but it gives you kind of an interesting view into what they will start looking like. So first is a quick little press release, initial press release. Next slide. And then almost a month later, a fulsome 8K that appears to more or less comply with the new 8K rules, and that gives additional detail on the financial impact of the event, which again was much more significant for them than it was for Caesars. It gives customers the information they need to call in to find if their data was lost. And so this is, again, a month later. So we're going, there's the immediate reaction, and then there's the big reaction, the update. And so you can see MGM handled that. Next slide is Caesars. And this happened over the same weekend. Caesars was a smaller incident, but you could see they were able to get their full 8K out within a few days. So they put out an 8K fairly quickly. Well, you can see it's a week later. It was September 7th, and they put this out on September 14th. But they gave the full 8K update. Again, it took a week. I mean, it takes some time, and the SEC has acknowledged that it's going to take some time. So we gave you these examples just so you've got some context and you can think about what disclosures might look like for you. Next slide. Next slide. I just want to circle back to risk factor disclosure. I know we're short on time here. Their SolarWinds complaint against their CISO and against the company came out on October 30th. The summary of it's here, but the important takeaway is to remember that the SEC has honed in on what they call hypothetical risk factors in the cybersecurity context. They started with Facebook in 2014, 2015. They jumped to Alphabet in 2018, 2019, and now they're getting onto SolarWinds. If all of your risk factors regarding cybersecurity say something like, in the future, we may have cybersecurity breaches that could have a negative effect on our financial condition and results of operations, but you have in fact had cybersecurity incidents in the past, that is not where you want to be. You need to be very clear that cybersecurity incidents happen to you, and while historically they may not have been material or material in the aggregate, they may happen in the future. So you've got to look at it, add a sentence if it's true, and say, from time to time, we have cybersecurity incidents, including X, Y, and Z. While to date, they have not been material individually in the aggregate, we may in the future have an event that could be material. Hypothetical risk factors, big no-no, and SolarWinds was called out on that. Next slide. Next slide. So just a few takeaways for you guys. Rajesh?
So the first one, companies should update and review their incident response plans There should already be pre-planned lines of communications established between the general counsel's office, the CIO, and a disclosure committee. There should be a team identified for this disclosure committee so that it can quickly identify materiality and make the proper disclosure. Companies should also onboard their cyber insurance provider and related service providers immediately upon discovering a cybersecurity breach. And they should also get their PR firm involved as well early on. We would recommend that a form PR statement be readied so that, you know, there's certain blanks in there and they can be filled out and quickly released if a situation is needed.
And then the next 3 items we've talked about: update your disclosure controls and procedures, train your IT team and your disclosure committee so that they know this 8K kicks in 6 weeks, and understands their responsibility for making materiality determinations. Review your cyber governance processes, begin drafts of your 10K disclosure, make sure the board and management knows which board committee has responsibility for cyber risk oversight, or the whole board if that's appropriate. And then finally, as a reminder, review your risk factor disclosure. Don't let it be hypothetical for events that may happen in the future when cyber incidents happen to you. Thank y'all.
Great. We can go to the next slide, please. Thank you. That concludes the presentation today. Appreciate your time and 30 minutes with us on these important disclosure points. We've got another installment of our tech series coming up on December 7th, where we're going to do an overview of standard technology agreements. We continue to finalize the schedule for 2024 and look forward to having at least quarterly some great presentations for the group. Don't hesitate to reach out to Catherine or Rajesh or me if you have follow-up questions that we weren't able to cover during the presentation, and enjoy the rest of your day. Thanks so much.